For some reason it's slow today. I don't know. I just paused in between. I might have to go back out and come back in. But here it comes. Okay. 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 You can let
Let
them
him
know.
in? Okay.
Yes.
Uh-oh.
Okay, Kimberly, whenever you're ready.
Okay. You wanna unpause it? I'm ready.
Okay, thank you. Thank you so much for reminding me.
This is case number 18013-969NF, Ocklock versus Progressive Marathon Insurance Company.
Good afternoon, council. Appearances for the record.
John Hocking for the plaintiff.
And Ryan Ewells on behalf of the defendant.
Okay, Mr. Yules, this is progressive motion, so you may proceed.
Thank you, Your Honor. I'm sure I won't, I'll keep it brief. I'm sure the court's read the briefs submitted by the parties, both my motion and reply brief, plaintiff's response. In sum, I think I guess jumping right to the response to the motion, I think the plaintiff, like I laid out in my reply, kind of concedes that they're not able to seek benefits in their PIP action for the three providers, M1 Imaging, Affetrix, and Beaumont, who did not at any point revoke the assignments.
Right.
So that one, I don't know, I don't see that addressed and no argument made as to that point.
Okay, let me just ask, excuse me, let me just ask Mr. Hocking that you don't have any problem with those because they didn't revoke their assignments, correct?
Yeah, well, Your Honor, I think this argument conflates the benefits from payment of the benefits, and I think that's an important distinction. So I do have an issue with that. All that is done with these assignments is give the provider the right to payment. In fact, most of all of the assignments talk about first lien on the right to payment. They talk about the provider may sue under the assignment. It contemplates the plaintiff who holds the benefits in this case. The statute says that you can have no assignment of benefits. Okay, that's been clear since the inception of the no-fault law. You cannot assign your benefits to anybody. What you can assign is the right to sue. And if the provider exercises that right to sue, then they do that under the assignment, that's fine. But until the insurance company is ready to make a payment, that's when these assignments come into play. That's when that's why on any settlement conference, the court says anybody with liens has to show up here to assert their position. But it does not take away from the plaintiff the right to bring a lawsuit for all benefits that are owed to him under the No-Fault Act. Because there's all kinds of issues that come up that are not just like payment issues. So this is a narrow right that was assigned, and it's only a possibility. The provider has the possibility of suing on their own, but they don't have to sue on their own under the assignment.
Well, let's just take that. Now, we know that this is a court of equity and the court has to do equity. And in this regard, the court is going to clog up its docket if by chance we have this and we have somebody else come in later and then you have the release and so forth. It creates a lot of problems. The question I have for you is, have you talked to M1 Imaging, what is it? Affetrix and Beaumont?
Have we talked to them? I have not personally. This is the main, Mr. Moomin's file primarily. He's in a facilitation right now. But, the way it works in my experience, Your Honor, and I think from a settlement conference, it's the same thing. We're not, the insurer is never going to have to pay twice. Okay. If this case is settled, there is a procedure for them to file a motion in front of Your Honor and name everybody, all the providers, and they have a right to come and say, hey, I'm owed this much, and so on. And an order is entered. That's
Okay.
the way it's done. I'm not
Mr.
sure if you're asking me that, but no, we haven't talked directly to Beaumont. I mean, they know we're suing on this. I mean, they're aware of it. They are
Mr.
aware of it.
Ms. Yules, let's stick to this issue. Mr. Yules?
Yeah, I guess it's a bit confusing only because plaintiffs seem to point out in their response, failure to cite to certain things on my part, which I did in my reply to kind of support the argument. Plaintiff seems to want it both ways. I'm going to assign my rights, but I also want to be able to collect and keep that number artificially inflated for purposes of facilitation, settlement conference, or other dispute resolution process. And then somehow put it, even though, I mean, the case law is clear. The assignment of the rights is the assignment of those rights that the plaintiff had in handing them over to the provider. Here, by the assignment of those rights, plaintiff lost the standing to bring suit for those bills, and putting it back, the ball, so to speak, back in my court or my client's court, and putting it upon them that if we do settle and quote unquote pay monies that would also include for providers to whom assignments have been made, then it's also on us to protect against providers who still have those assignments that are apparently valid in the plaintiff's eyes to come back and sue me again. And
Right. That's what I'm talking about in terms of a court of equity and doing justice and doing it once. It's problematic. Like I said, I see these all the time. If there's an issue, more so than not, and then the first note that I put was, had the providers revoked their assignments. That was my first note to myself. And I see that relative to orchard toxicology and what is it, Farmbrook, that they did. And so that rectifies that situation. I know, Ms. Hawking, this isn't your case, but at this juncture, I'm prepared to at least to grant that in part and dismiss it without prejudice. But there, the line has to be drawn somewhere. Providers are allowed to come in, to utilize their assignments to be joined to actions and so forth and so on, if in fact they want to have an individual claim. But I don't see where the law tells me that relative to people who have assignments that I just have to leave them in if they have an assignment.
Well, but they're not in this case, so I don't know what that means exactly. Leave them in.
That their claim can be asserted in this action when they have an assignment.
Your Honor, if we look at what the purpose of these assignments are, this allows the person to be treated without having to go to the insurance company and say, hey, are you going to pay this bill? Because they don't do that. Okay. They never have. They won't authorize payment until after it's incurred. So this this allows the person to go get treatment and on a continuing basis, and it protects their provider. And that's what it's designed to do. It gives the assurance to the provider that, hey, if you, for whatever reason, don't sue to collect these benefits or to collect the payment of these benefits, then we can do that. But it doesn't say that they have to sue, that they're the only party that can sue. The language in the assignment basically says either party can sue, either the injured party, and that's what's important.
Okay, show me where in the assignment does it say that either party can sue? Tell me, show me where that, I don't know that language does appear in the assignment. Let me see if I can find
Yeah,
this.
on Dr. Kim's assignment of benefits.
Wait, let me, okay, I'm looking at, I think, yeah, I'm looking at his.
There's like a ton of those that he attached. You know, I mean,
But
this
let's just
document.
Okay, but let's just look at one of Dr. Kim's.
Okay, so if you go, I think they're all the same, Your Honor. I'm not 100% positive, but if you go the second paragraph to the bottom, it says, a signer understands that should a signer contract with or retain their own counsel to seek his or her no-fault benefits, that counsel shall not have right to payment. They're talking about payment of plaintiff's counsel. Here, let's see. I think maybe it's, oh, here it is, above, 2 paragraphs above. Asinor hereby certifies its understanding that while Asinor may pursuant to the assignment pursue payment from a person, this agreement may be revoked. So the language is not mandatory. It's not saying that because of this assignment, the provider is the only one that can sue the insurance company. That's absurd. That's never been the law in Michigan. Counsel has cited no case law for that. The one case that he relies on has to do with the 1-year back rule. In that case, which is Shaw on page 3 of his brief, what that says is that the assignee, the provider, gains no bigger rights than the injured party. So that if the 1-year back rule could be asserted against the injured party, the plaintiff, that the assignee can't get around that. But it doesn't say anything about, well, an assignment takes away the right for the plaintiff, the injured party, to sue. It just doesn't say that.
Your Honor, in my reply brief, Weston v. Dowdy, 163 Mishap, 238.
What year is it? Because
1987.
I'm sorry, 1987.
Yeah, as set forth in defendant's motion, an assignment is the transfer of rights held by one party called the assignor to another party called the assignee. I mean, the case law is clear on this. The assignment of the right is transferring the ability to sue over to the provider. It absolutely would create a more craziness than we already have if both parties could sue and then leave it up to the insurance company to go try to collect from someone. That just goes against all logic.
But see, excuse me, I don't understand. If it's not, see, it seems like it must be problematic, because if it weren't problematic, we would have a revocation from Beaumont, from who was it? Beaumont, from M1 Imaging and Effectrix. If this wasn't problematic, then we'd have that. I see that something's going on, and it's going to create more problems down the road, because I understand that Farmbrook did revoke theirs, as well as I keep forgetting.
Orchard.
Yeah, right, as well as Orchard. I see that they revoked it, but because Beaumont didn't and Effectrix didn't and M1 didn't, I see it as being problematic. And like I said, we don't have Mr. Who is it?
Moomin?
Yeah, Mr. Moomin here, to assert that, because it seems like it's a problem. If just like you got
something, am I wrong? If this case, for instance, if this case settled, okay, and we had the insurance company agreeing to pay, X number of dollars, would not there be a procedure that they put notice on to all the providers, and we have a hearing on that? This is what protects the insurance company. This is the format that I've done many times in circuit court. I'm not sure.
I understand, but the thing is, there's an assignment here. I know full well in terms of when we have the 3112 hearing relative to what providers are in or out, but this is a situation where there's clearly an assignment. You know, that's
but-
the problem. I understand 3112 motions. I do them all the time. That's not what I'm
Exactly.
talking about. I'm talking about the case here that there's an assignment. And if it wasn't problematic, why did Mr. Mumi get the revocation from those three providers? That's my concern.
Well, I think,
Fair enough. And that's a fair concern, Your Honor. I'd like to be able to address that. I'm not trying to delay a result on this case. It's a fair question. It's a good question. There may be a good explanation for it. It may be, a lot of times this stuff is done a little bit informally, like a call is made to the provider, to Beaumont, and they say, yeah, we know you're suing. When the case is settled, you pay us. Yeah, we will. That kind of a thing. That may have been done in this case.
Okay, but I don't know that because we have a settlement conference today. How can I have a viable settlement conference when I don't know what's going on with this claim?
This is a
I can't
settlement
even,
conference
I
too?
can't, I'm sorry.
This is a settlement conference also, Your
Yes,
Honor?
yes,
I didn't-
there's a settlement conference scheduled for today. I can't have a settlement conference without knowing this information. Like I said, I'm prepared to just, take them out, we'll deal with them. And like I said, if Mr. and this is what I might do. I'm inclined to grant Mr. Yule's motion, but I will take it under advisement for 7 days. And if in fact they have they revoke it, fine. Otherwise, I'm granting it as to Effectrix, M1 Imaging, and Orange, because we can't even have a meaningful settlement conference today.
Well, I hate to ask for this, but if I would like to just address this with Mr. Moomin careful for a couple seconds, if the court would indulge me, and just ask him if he was aware of that, because I was not told that. I did not know that there was even a settlement conference. It may have slipped his mind. And I know it's hard to believe, but we're pretty swamped in this office, and I would just like to see what he says about that, because he may be done with his facilitation now also.
Mr. Hughes, were you
Can
aware
I
that
do that,
there was
Your Honor? Can you
Wait,
give me
Mr.
30 seconds?
Wait just a second. Mr. Hughes, were you aware that there was a settlement conference today?
yeah, my understanding, and I don't, maybe we're just missing terms. I think it's a final pretrial.
Same difference, but
same
there was
difference, right.
settlement discussions.
I do
'cause
have,
I'm looking
I
at
do
it
have-
on,
I'm sorry, Judge.
I'm looking at it on Odyssey as a final pretrial conference and the motion hearing today.
I do have my adjuster available by Zoom if necessary. She can, I'm supposed to text her and make her available.
Right, and that's what I'm saying, even though we were supposed to discuss settlements today, that's the bottom line. So, Mr. Hocking, if you want to try to reach out to him.
He's right in the other room. He's just so the court knows. It's not like I have to go anywhere. He's like a couple offices over. So if I can just go talk to him briefly, I'll be right back.
Okay, we'll pause the recording.
Thank you very much, Your Honor.
Thank you. So just to know, Mr. Hughes, we're still on YouTube Live, so this is still being
Thank you.
not recorded, but it still is being disseminated to the public.
Has to be a little bit eerie down there with an empty big building.
But it's safe.
Yeah, that's true.
It's safe, and they opened up the city side last week, and it hasn't really been as good as it should have been. Let me just say
Oh,
that.
really?
Yeah, there's been some issues.
Yeah, that's not good.
Yeah, so
Yeah, if everyone would just do their part, I think would be it'll still take a while probably, but be in a better place.
Right, because that's, you know, that's the problem. People, I don't know why people think that this isn't real.
Yeah.
And just like in Florida, all the people that were on the beaches until they closed them. You know,
Yeah. No thanks.
right, right. Let me ask, has this been, this hasn't been facilitated, correct?
It has.
Oh, it has, okay.
Um,
I'll wait till he gets back if it has.
Yeah.
Okay.
Two of us here.
She's got us on hold probably.
Okay. No. Okay. Okay.
Hey, Jack.
Okay. How are you, Mr. Mummy?
I'm still alive, Judge, with this COVID so dangerous here. I'm still alive and I'm trying my best. I have old, my father is really old, so he lives with us, so I gotta be very careful going.
Yes, you do. You really do. See, that's the problem. It's like the younger folk don't understand. It's not necessarily them. It's who they can infect and who has some predisposition. So I applaud you for taking the extra precautions for the care of your mother. And I don't know if you have young kids, but they need to be mindful as well.
Yes, because it's really tough. He has a bypass surgery, kidney disease and stuff. So everywhere I go, I just keep showering, washing my face. It's
Right.
too stressful.
It is stressful, but you know, we have to do what we have to do to protect our loved ones.
Exactly. Yeah.
Okay, so now I don't know if you are aware, the issue that I'm having is relative to M1 Imaging, Vectrix, and Beaumont. Have you communicated with them in terms of their assignment?
Yes, Judge, I communicated with their assignment and the M1 imaging, I'll get a waiver of the assignment from the M1 imaging.
Okay.
I think they have, for the Beaumont, as you know, this is the hospital bill, and it's really hard to get them, the legal department, to write something.
So I think that's why I'm saying, I think we have to exclude their bill because I don't, you know, with them not agreeing to it, they're either going to have to pursue it on their own because, you know, this was the date time set for not only the SD, but
Yes.
for the discussions for
Yes,
settlement.
we can exclude Bowman's bill. I'm fine with it. I don't have a problem. If I don't have assignment, I don't have assignment. If I
Okay.
don't have the waiver of the assignment, I don't have the waiver of the assignment. I
Okay,
can
so
exclude the Bowman bill.
okay, what
and
about
remove
effectrix?
Orchard toxicology, which one?
Effectrix. Effectrix.
Yes,
I
we
don't know
can
how much,
exclude. If I don't have, yeah, if I don't have the waiver of the assignment, I'll waive the bill.
Okay, okay, so what we're gonna do is we're gonna grant the SD in part as to Beaumont, M1 Imaging. No, I'm sorry.
No,
Beaumont
I'm on the
and
meeting, I'll get the waiver.
I agree. I heard you. I misspoke.
Okay,
So
yeah.
the court is going to grant the summary disposition only as to Beaumont Hospital and effectrix. So Mr.
That's
Yules,
without prejudice, correct? That's
without
prejudice.
prejudice, without prejudice, yes. Mr. Yules, without prejudice.
Yes, and Your Honor, just, here's my, I guess, we're unfortunately maybe creating issues. And I know you keep referring to the settlement conference portion of it. Is the next, or the third kind of part of the motion argument today is with regard to those assignments. I would at least like the opportunity. I haven't seen the revocation or waiver of the assignment from M1 Imaging. And I don't even, to be honest, I don't know the amount of that bill and how it will impact any ability to argue or to, I'm sorry, not argue, but negotiate with regard to settlement. The other part of that is, sorry, Your Honor. The other part of that is that on the third part of the actual argument, I'd like to know at least the date of that waiver, or if it's the same date as the waivers for Orchard and Farmbrook, at least know that so that we can proceed with argument accordingly. And I can take the court's direction on that.
Well, as long as, and this is my position relative to that. If they have a waiver, the court is going to honor the waiver. The court doesn't feel that the date of the waiver has any bearing because this action was filed back in 2018 and they were included then. So the court is not going to have any, accept any arguments relative to claims being barred for any reason, if in fact they were part and parcel of the initial action. So the date of the waivers has no bearing on us going forward.
Okay, well, that answers my argument on the third part. If the court wants me to make any record of that, I will, but I appreciate the court's opinion and efficiency.
Okay, and like I said, your briefs speak for themselves.
Sure, okay.
Okay, so like I said, the court will grant the SD in part as to Beaumont Hospital and Effectrix LLC. And those claims will be dismissed without prejudice. So we will, in terms of the providers that were at issue today, Farmbrook, Orchard Toxicology, and Mr. Mommy, you do need to present the verification of the release, the waiver or the revocation of those for M1. Did you provide, and I think you're the ones for Orchards and Farmbrook were attached, correct?
Yes.
Okay.
Correct, Your Honor.
Okay, so Mr. Mommy, you need to get Mr. Yules within 7 days your waiver from M1 Imaging. And Mr. Yules, you can place that in your order.
Okay.
Good. Your Honor, there's another issue that counsel raised that frankly was kind of totally confusing. And he didn't really go anywhere with it because he didn't say how the offset of Social Security disability benefits affected anything. He just said, hey, we're entitled to an offset. Yeah, we don't dispute that. That's the law.
That's a separate and distinct, that would have to be a separate and distinct argument or motion filed relative to that.
No, I thought
It is part of our,
But what I'm saying is we don't know what it is. Do you, Mr. Yules?
as far as Well,
the,
no, the argument is, and I think based on the response brief and then what counsel just indicated, I don't think there's any argument that we're entitled to a set off
correct.
of the Social Security disability from a wage loss claim. I guess there is argument potentially over what that amount would be. If
That's what I'm
the court's.
saying.
Okay.
That's what I'm referring to, because I'm not saying, I understand, but in terms of what it actually is, that's for another day.
I don't disagree with you, Judge. I think our motion was just clarifying that, yes, we are entitled to it. I don't think that was the second part of my reply brief, is basically plaintiff doesn't seem to take issue with that, other than to the extent of what that number actually is.
And
Exactly.
I think
don't have
we're, Mr. Moment,
Yes, I don't have any problem with it. I gave him all the Mr. McMaster, I gave him all the proof how much he made, how much he get from the Social Security disability. We can deduct his amount. He has
Okay.
it.
so I guess Mr. It's not, doesn't seem to be problematic, but Mr. Ewell, in terms of that, how do you want to address that in the order? Because I think it's a no-brainer.
Yeah, I mean, if plaintiff's
have to
counsel
do it.
if plaintiff's counsel is okay with it, I'll just say something to the effect of defendant is entitled to a set off
From Social Security.
per the arguments set forth on the record. I don't know, something I'll think of something, but nothing more than that, because obviously the dollar amount is going to have to be determined.
Well, maybe just say that the defendant is entitled to a set off for Social Security is it disability?
Yeah,
Social Security disability, and the amount to be determined at a later date.
perfect.
Perfect.
I'll include that.
Okay, all right, so let's, I just want to end the motion here, and then we'll deal with the settlement conference. Is there anything else for the order? So Mr. Yule, you're clear in terms of the relief that'll be provided in the order?
I believe so, Your Honor. Thank you.
Okay, so this concludes the motion for summary disposition hearing. All right, in recording, and I'm going to end YouTube.